5, 4, 3, 2, 1. Opposing these submissions, it was contended by the learned government advocate that once an appointment is made under Rule 5, the right to be appointed is consummate and cannot be reconsidered for betterment of the services. The learned counsel placed reliance on some decision of this court for this proposition. The intention of the state or the instrumentality of the state in providing immediate appointment on compassionate ground is obvious. It is to provide immediate earning facility to the family of the deceased employee so that it does not further suffer because of the death of the employee. The entire provisions in this regard stem out of compassion existing in the state for its deceased employees. These rules do not and should not create any preferential treatment in favor of a dependent of a deceased employee. The appointments offered on compassionate ground in exercise of the powers of these rules are extraordinary appointments given for a specific purpose and therefore amount to a reasonable restriction on the mandate of the Constitution given by Article 16 thereof, that there shall be an equality of opportunity in the matter of public appointment. A preferential appointment without competition or consideration of other eligible candidate would normally vitiate the mandate of Article 16 and would therefore be unconstitutional. It will be seen that the Constitution of India has provided equality of opportunity in the matter of public employment by Article 16. Article 16 reads as under: Equality of opportunity in matters of public employment. 1. There shall be equality of opportunity for all citizens in matter relating to employment or appointment to any office under the state. 2. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. 3. Nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government or any local or other authority within a state or union territory any requirement as to residence within that state or union territory prior to such employment or appointment. 4. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the services under the state. 5. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denomination institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. It will therefore be seen that a provision made for giving appointment to a dependent of deceased government servant in preference to others who enjoy equal right of consideration for appointment to a government service is protected merely by reason of being exception to Article 16. So viewed, the rules providing for compassionate appointment will have to be construed strictly and cannot be construed widely and as benevolent legislation. A careful consideration of Article 16 and the principles embodied therein demonstrate the desire of Constitution makers to create equality in the matter of public employment, and then equal right is therefore given to the citizens. These rules, which do away with this right of equality, therefore form an exception to the general rules enshrined in Article 16. Being an exception, therefore, the canons of interpretation requires that it should be construed strictly according to the rules of interpretation. Therefore, the provisions will have to be construed strictly. I have therefore to consider the scope and extent of Rule 5 of the rules applying these canons of interpretation. The interpretation given to Rule 5 will have to be such as it does not conflict with the principles of Article 16 of the Constitution. A scrutiny of Rule 5 will further fortify this contention. It provides for grant of appointment without delay only against an existing vacancy to a post which is not within the purview of the State Public Service Commission. In relation to normal recruitment rules, suitable employment is to be given. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.